This particular um, live stream is focused on a discussion about its state courts, Commonwealth, courts of Commonwealth, law, and questions and answers, responses to those questions. And also, we will make some reference to um, answers as it is related to um, court practices. So we got to understand the difference between when we use these words, what we're referring to at the time and in context. And so that's why I made pointed out the distinction between the two words. I mean, the two understandings, the two differences of understanding of the words. So we will be providing answers to questions that were left in the comment section. As well, we will be giving some information on how to give legal answers and what a legal answer is, and the difference between a legal answer and a response. We'll hopefully provide some insight on the difference between a complaint and a petition. Okay, so that you understand which one you are performing when you do submit these documents. It's considered as performance. And so that's why I am referring to your action as a performance, because lawful performance is when you give an answer to a claim or a complaint against you. Okay. However, if the complaint is not lawful, then you would proceed with a response that it is unlawful. You wouldn't answer to something that doesn't even qualify as a valid complaint. You wouldn't answer that, you would respond to it. And that's the difference between answer and a response. Is an answer is based upon guilt and or innocence. Okay? But a response is based on merit of the claim to begin with. What's the standing? What's the jurisdiction? What is your jurisdiction? We're not going to even discuss whether I'm guilty or not. What we need to discuss is, are your hands clean? It's sort of like claiming what they call in court practices unclean hands. It's a claim of unclean hands, perhaps, that the person does not have standing or jurisdiction. Then they are trying to proceed in a venue that does not have jurisdiction, which does not allow them to have standing before the court. As with a lawyer, a lawyer does not have standing before the court because he does not possess firsthand knowledge. His position itself is a second-hand position. And there's no way that he can make any claims on the record that would be considered as affirmed, an affirmed record. And this why in the court of competent jurisdiction, which is most commonly referred to as common law, uh, the common law supersedes the trial court rules and procedures because common law is what governs every um, court practices. And I saw um, a broadcast where they were saying that they'll try to hide that common laws is very much alive and well and in practice today, even within the court systems, because they're trying to train the masses to believe and put trust in the color of law, what appears to be law. Thank you for watching. I appreciate those of you who are watching. And please leave your comments, questions regarding this subject. We're talking about writs, and we're going to be discussing in depth. We're going to have a display information from or prevent it from doing something. Those are the. We're going to have a display from this channel, ADR Services Inc. If you'd like to go over there and subscribe to their channel. Um, I have not subscribed yet. This is the first video that I believe that I've encountered to assess what type of content they provide. So far, it seems to be reputable. The guest that are speaking system, and what they are discussing first and foremost is the superiority of common law. So in that regard, I don't sense that any type of deception to is created in this presentation to make people think that common law is not in full effect and in practice, because you will see. I'm going to rewind back a little bit. Right about here is when it does begin to speak, I think. And so we'll start the video right there and let it rip. As kind of an introduction to appellate writ practice for civil trial litigators. Obviously, we can't cover things in great detail, but what we want to do is hit some of the highlights. We've prepared written materials as well that I think are fairly complete, and we've also, as you can see here on the slide, you need not write down these authorities at this time. We've got them in the written materials, but we've also tried to provide the rules of court and secondary materials that can help you with some of these topics when you come upon them in practice. The way we're going to divide this is I'm going to speak first. I'm going to talk about the technical procedural requirements of appellate writ review. Then my colleague Judge Goodman is going to talk about some of the orders you will see from the Court of Appeal and how the trial court handles what happens in appellate writ practice. And finally, our colleague Andrea Ventura is going to provide some really helpful practical advice on how writs are evaluated and assigned, and some of the important things you should know to maximize your chance of success. So let's begin. We've got a lot to cover here. The first thing I want to do is give kind of a reality check, which is the following: that the chances of receiving appellate writ review overall are extremely rare. 90% of extraordinary writ petitions are denied summarily. They're called extraordinary writ petitions. Okay, now he's gonna do a little bit of explaining. but I will fill in the blanks right here and do a little bit more in depth so that people are understanding from what perspective that he is speaking on when he's speaking of uh, the data and the success rate of people who have uh, commonly uh, submitted these type of documents. Okay, now what he is quoting is not related to extraordinary writ. What he is actually is referring to is that many times if your case and how you wrote it was plain and ordinary, then they will reject it 90% of the time. If you have worded your petition correctly as a petition, it cannot be denied. That is the part he is not disclosing because I guess in consideration of his colleagues, he didn't want to be the cause of a sudden flow of documents being submitted to the courts um, in this category because they are trying to um, kind of ward you off from submitting these type of documents. This is the reason why they tell you this statistical data without telling you the in detailed facts that most extraordinary writs are received. They're not received by the appelling court. Okay, so he is correct in saying that they are not received or that they're rejected. But what he is not disclosing, and I think is a little somewhat intentional, is that um, extraordinary writs are not accepted in the appellate level because the appellate level is not the higher court. And these type of writs are supposed to be drafted and submitted to superior courts. See right here at the bottom it says Omaha Indemnity Code versus Superior Courts. He never mentioned that, but it's on the screen. So you got to pay attention to what's really going on in the picture. And then in here, he called them petitions. In the writing, he called it petitions, writs, and petitions. And it says they are summarily denied. Because if it's summarized, if it's easily summarized, that's what summarily means. That means it's a common practice and it should not be submitted as in an extraordinary writ. It's misplaced. The venue is misplaced. So in court language, that means you have submitted a claim upon, you have not submitted a claim in the proper venue. Okay? That's the only reason it's being denied. And or you didn't make your claim clear and concise to give the court some insight on where the offense took place. Some people lack standing based upon how they wrote their own claim up. You didn't claim enough, or you didn't claim the right thing in the right uh, capacity.
Because it's extraordinary relief. You're trying to bump to the head of the line of the other things that the Court of Appeal has to do, namely, primarily appeals. And so, generally speaking, absent certain requirements, the writ petitions are not.
Wait a minute now. Now, did you hear what he just said? He said this procedure of filing a petition is basically used in practice to jump to the head of the line. But what he really means by that is it automatically gives you priority, okay, and puts you at the head of the line. So if you're being placed at the head of the line, wouldn't you think that there would need to be a reason that you were placed at the head of the line? And so what many courts are looking for is that wow factor. Like, oh, I can't believe these people did this. This is definitely out of the ordinary. And they have to take the case. They have to take the case. They cannot deny it. And that's the part he's not disclosing for whatever reason. Let's move on.
Successful, but those 10% that are can be very, very important for your client. Generally speaking, appellate writs are divided into two general categories. The first are what are called common law writs. They are called common law writs because a specific statute does not authorize them to review a particular ruling by the Superior Court. I've got a list here on the slide of the most important common law writs. Really, the two that we're going to worry about here or talk about are mandate and prohibition. Certiorari is a writ that you probably know from Supreme Court review. I mention it only to be complete because it is a type of common law writ, but it generally doesn't come into play when we're talking about reviewing trial court rulings pre-trial, which is what we're going to be reviewing with extraordinary common law writs. Writ of mandate is the most common writ. It's used to correct an abuse of discretion for our purposes by the trial court or to compel the trial court to engage in a ministerial act. The second fairly common writ is prohibition. It's used to prohibit the Superior Court from carrying out a threatened act that is in excess of its jurisdiction. Sometimes you'll be petitioning for writ of mandate or in the alternative writ of prohibition to either have the trial court do something or prevent it from doing something. Those are the major common.
Wait a minute now. Wait a minute. Wait a minute. Now, something in the milk ain't clean about this middle one right here. There's a little deception in there. Okay, I'm going to point out what I mean by that. Let's zoom in on this motherfucker if we can. Hold on. There we go. Oh, yeah, let's zoom in on it. Find out what's going on in the picture. It say a common law prohibition, right, is used to prohibit the Superior Court. Wait a minute now. Wait a minute. If the court is superior, then how can you prohibit a superior court from carrying out a threatened act that is in excess subject matter or personal jurisdiction, or in excess of its power to act? If that court, okay, I just read out what they have written here to spellbind you, okay, into thinking that their courts are superior and you need these writs to stop them from being superior. Well, that means that you're not superior to begin with. That's the reason why the Supreme Court is called supreme and not superior, because the Supreme Court is not superior at all. It is a lower court to the superior court, which is the people's court, which is the superior court. And there is no uh, paperwork that you can fill out that can rule out the authority of the superior court. This is what their systems is doing. It's trying to prohibit the common law superiority. Even just this statement is um, misleading in nature. And it's a color of law being portrayed in just this statement. And this is a falsehood that's being portrayed, that the Supreme Court is the superior court, and it is not. The actual superior court is what we call lower courts, or we refer to as lower courts. The county clerk is the highest court record in common law. And maybe perhaps they were not aware of that because they're taught policies and procedures. So we're going to give them a pass and say that was um, excusable neglect in relaying proper information, valid information. It's an excusable neglect to distinguish that. And whoever created this slide might not have even been aware that there's a difference between the words superior and supreme. Okay? Moving right along. It may not have been intentional deception. Okay? But he also goes on to speak about the writ of certiorari as if it is not a common practice, when a lot of people who are in prison um, use this document. Is very common practice for people who have been wrongfully imprisoned for a crime. This is used in criminal offenses, and it's very common. So for him to wave this off as, oh, people don't hardly use that, it's because he doesn't want people to know and understand the importance of this document. We have also some videos of the writ of certiorari, and we're going to do some more videos on writ of certiorari because people need to understand what a writ of is. A writ is, or a writ of review. What is a review? What is a injunction or remedy? What is judication? What is jurisdiction? What is standing? And you see right here, this clearly tell you writ of review. That's what supposedly a writ of certiorari is. And is used to remedy a completed judicial act in excess of jurisdiction. And they put in here in parentheses, not important for our purposes. Wow. 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 Mm-mm-mm. Right there in your face. They told you basically that the Constitution is irrelevant because the only grounds that you may stand upon to exercise a writ of certiorari is certiorari, okay, is the grounds of stating that the person does not have standing or jurisdiction. And so what they're basically saying is they don't want to hear, they're not going to teach you how to challenge their own jurisdiction. That would be a conflict of interest. So they were clear in disclosing that they have no intentions of teaching you anything about that in depth, okay? That's right there in yellow and blue, okay? It's not in black and white, it's in yellow and blue. Gotta learn the meaning of your colors as well. But it's right there in yellow and blue. Full disclosure. We ain't telling you shit about that. Excuse me. That's basically what that means. That's not our intent to teach you how to assert our authority. And you can understand that. You can relate to that. That's just like telling somebody how, where you, if you have a business, right? And that's like telling somebody how to put you out of business. That's a conflict of interest to yourself. And so that's not purposely or intentionally trying to hide the law from you. They openly disclosed that that was an option. And so they they presented it to you. And because if they don't do any further explanation on that and you choose not to look into that option further for yourself, that shows that you are a minor. You have no business using that uh, option anyway. That's why it's not pertaining to you. You may say for our purposes, but it's not important for their purpose for this video to tell you how to usurp their authority. That's what certiorari means. You may call their certifications to the record, and you can require that they meet the proper policy and procedures to make judgment upon the record. And many times that's done by making a claim that a constitutional violation occurred in the procedures prior to the writ. And once that has been done, uh, then you can. It's not an accusation that they are acting under a color of law. Now you have evidence based on the case or proceedings that they proceeded on with. And then with that documentation of the proceedings, you have evidence of your claim. If you can properly point that out to the on the record to the record. and show cause. You're showing that you have a cause that is worth the court taking a look at it, the higher courts to take a look at it and say, okay, these uh, those that have made the person who made the judge that made the judgment in the lower court has gone outside of what is he's allowed, his judicial discretion of what he's allowed to do, and he or she has violated the law in doing so. That automatically is an approval of writ. It's an automatic. It's an automatic an approval of an appeal. Okay, a lot of people don't get um, turned down to even for their case to be heard on appeal simply because they didn't understand that the only thing that matters in appellate court is an error made at the lower. And when you point out a judicial error and you can uh, use the proper codes and terms to describe what the error was and make that very clear to the court, not throw it at the court and hope they can figure out where the problem is. And that's why your case get dismissed. You were supposed to took care of that yourself. That's what a case is. That's what the preparation of a case is. That's what the body is made of. The substance of the case. What's going on? The who did what of the case. And how was they wrong when they did what they did? They have to be wrong. You can't just say somebody done something, because if they done something and they have the right or authority to do it, then you still don't have a case. You only have a case if they did something that they do not have the authority to do. And then you have to prove that they didn't have the authority to do that. And accusations based on a YouTube video is not proof. You have to have competent evidence, what they call genuine issues of material facts, to support your statements. Or otherwise, they are only allegations. That's what an allegation is. It's something that cannot be proven. That's why it remains an allegation. It remains in allegation status until you can submit some type of evidence that will move it over on the board. It'll move it over to be submitted into evidence. That's why you make the statement in court. I move to submit Exhibit A into evidence. Those are your exact words. It's like moving a piece on the board, okay? And you upgrading that piece like they do in chess when you say you move over to your opponent's side and they say crown me, you know. And so it is the peon game. We talking about chess and not checkers. And so in court, that's the way you operate. In chess, that's the way you operate. Move your piece. You move to submit evidence. Okay. Otherwise, you can remain sovereign and you can choose to give a response instead of an answer. Okay. And I'll be giving some demonstrations so that people can understand the difference between a response and an answer. more clearly uh, through um, by example. Okay, because all of these different types of writs are foundational to law, and it's important that you understand uh, what what it means when you submit these documents, so that it will not be denied. Okay, and this is why having judges, these are judges and people who work in this field, who have seen cases come, seen cases go. They've seen cases won, they've seen cases lost. Okay, who won and who lost. And they can tell you, especially the judges, by which measure did they make the decision to throw out what they call throwing out the case, meaning tell you that your case is not sufficient to proceed. That's called throwing it out. Okay? I mean, you doesn't mean your case is invalid. That means you need to start over from the drawing board and um, understand how courts work, and first of all, understand what is a claim. What is a claim? And what's the purpose for court? A lot of people get into court and they don't even understand the mandates of honor and dishonor. Rules and any document you submit, honor and dishonor. And the rules of affirmation is sealed by the rules and the integrity that's underwritten. It's like a unspoken language that, I mean, an unspoken understanding that everybody must have. It's not a secret. It's something we shouldn't have to tell you to be honorable. It's not a secret. It's only a secret to you because you want to be dishonorable. That's why people think stuff is a secret. Ain't nothing a damn secret. It's been told to you all your damn life to do the right thing. Okay? And right here it says right here. Uh-oh. Shucky. Well, if it doesn't go back to it, then it wasn't meant for me to go back to that. Okay? So let's move on.
Those 10% that are can be very, very important for your client. Generally speaking, appellate writs are divided into two general categories. The first are what are called common law writs. They are called common.
Oh, also, I wanted to point out before we move on, because it's very vital and essential that we understand that what I am about to say pertains to people who are seeking sovereignty or diplomatic immunity. The reason that you would, in any case, submit a response as opposed to an answer is because God's cannot be summoned. Okay, to court. And when you go to court, they do what? They send you a summons, and you come when they say come. All right, and that shows like you're subject to them when you come when they say come, and you go when they say go, and you do what they say do. If they say go to this courtroom, do this, fill out this paper, do that, sign right here, and you abide by their ruling, and do what they say, then you are not ruling yourself. Okay? And that's what sovereign ruling is, ruling of yourself. Not to rebel against someone with proper authority, but in this case, in those cases, many cases, they do not have they only acting like they have proper authority. They do not have. They are actually acting outside of their jurisdictional perimeters, and they are acting under what's called a color of law, which is a civil offense. It's a crime. It's wrong. It can be prosecuted. Okay, many of the things that they are carrying on, the acts. Okay, and they are not no longer if they are acting in any manner that is harmful to you, they have already crossed over the boundaries of immunity and have acted under their own jurisdiction. And under their own jurisdiction, anybody can have their own jurisdiction, but they also are liable and responsible for any acts within their own jurisdiction that is a crime or an offense to someone else. Okay? And each person has their own jurisdiction. Every person has their own jurisdiction. Now, many people yield that jurisdiction subject to society or subject to their parents or subject to their mate, all right? And they become submitted to someone else's ruling or governance, to society. Some people do it, in more than one area. They allow other people to um, provide a ruling or a measure for their moral standards, okay, and what they will and will not do. Some people are a renegade and they don't believe in following no law, okay, but that's their law. Break all the laws, that's their rule. That's their motto, so to speak. Their mission in life is to break all the rules. You see people with T-shirts like that. Yeah, break all the rules. A lot of rockers would like something like that. Yeah, break all the rules. Speeding on the highway. Ain't nothing wrong with that if nobody's in front of you. Ain't nothing wrong with that if you're on the surface that don't pose a hazard for you to spin out of control. Ain't nothing wrong with that. Uh, Driving fast. But what is wrong with that scenario being depicted without any perimeters of safety is that the minors will grab a hold to that and just think that means, you know, free falling, you know. They think it's free falling time. Jump off a cliff time. And that's how uh, what you're saying may have validity, but you're releasing it irresponsibly. It's like having just popping off a gun in the air. You don't know where that bullet gonna land. It's irresponsible. It's very irresponsible. And a lot of the lawyers, the reason why I prefer to look at videos from people who are moving into the sovereign capacity is because they have more in-depth understanding of the law than people who so-called practice the law. They just practice it. This is why the man just said they lose 90% of the time. And you got to understand why they losing 90% of the time. Because they just practicing. They don't know no better. They babies themselves. And then on top of that, a lawyer can not file a writ, a pro se operating under common law can forward a writ. And generally, those who understand common law wouldn't even send that type of documentation to the appellate court. That's not even where it goes to. That's an improper venue. That's why it was turned down. You were supposed to send that straight to the Supreme Court level, federal court. Because if there's a constitutional question, that automatically qualifies it for Supreme Court level. And you need to prepare your petition accordingly. There's a table of contents, and you have your table of authorities. You have to send a cover sheet. You got to send all types of, indexes. You have to send all of this information because what you want is to make sure you have a proper presentation of your case so that it can be addressed as important. You need to present it like it's important. Why would you just what they call shotgun a case that's important? Just throwing shit at the wall like spitballs, hoping they stick. And that's ugly anyway. Presentation, okay? Wise. The optics of that. And you balling up spitballs and you throwing it at the wall. That's the optics on that is tacky. Okay? So when the courts um, make reference to your case as being such, that's the ultimate insult. And you need to regroup yourself and take notice or get out the field because you don't belong here. This not your area of expertise because this is what court is about. The proper presentation of information that is easily and can reasonably, by any reasonable thinking person, can calculate an understanding from what you presented to the court. Anything reasonable thinking person. And that it wouldn't take a rocket scientist to understand what you wrote. And it wouldn't take somebody who was born back way back in the old English time era to understand your heretofore with and above uh, and aforementioned comments. It's ridiculous. And since you are not trying to write the King James Version over again in your case, what you are trying to do, and a lot of people not understanding, since the law came from the Bible, that's why people used to write cases in that manner. Let's stay up with the times and the era in which you are presenting these documents and be realistic that futuristically uh, who could or would understand those documents to carry out the instructions if they can't even understand who a four with a two and up and beyond and or around and back and forth and two is you talking about? Just stop it. It's ridiculous. Even in speaking of your family line, for example, and if you were to start naming out all the people in your family and trying to go back as far as you could, as many generations as you could recall in your mind, or that you could get a record of who was married to who, okay? That in itself is called genealogy. It's what your genes are made of, what you are made of, who, what, and the history of your genealogy. Now, that is important to document. That's very important to document. And so, if you are being very specific as to who you are born to and who bore you and how did you come about into a manifestation of existence and who it took, the joining of who that created you, them and their parents before them. All of that was consistent in the creation of you, okay? And consequential to the creation of you. And so it's not irrelevant in a will to express or to make sure that you have your genealogy, your history of your bloodline in there, your heritage of family and related, how they are related. This person married into this family. His name was uh, King, and then that's how we got the King family. Okay, my grandmother's married to a king, and that's how we got King. Okay, and my grandmother on my father's side was married to a Marx. That's how I acquired the source and of heritage from the Marx family. Okay, but my real father, birth father, was uh, his birth surname is Brown, and so that's how I, by birth, was given the surname Brown from my father, the heritage of my father. Okay, and so in that regard, if you were to be specific in mapping, that's a map or a diagram of your history, where you come from, who made you, who created you, okay? And all of what you are knowledgeable of as far as family line that it took to create you. Because when that type of information is properly documented, you don't, it's more fortified in in heritage because you're not losing that information and that vital data. That's what vital statistics, or it's not statistical data, it's real data. The vital statistical data is data that's guesstimated, okay? It's guesstimated around about and all of that. But the information you hold within you is bona fide and is sure. And that's the reason why your word supersedes the lawyer, even though they make it seem like The lawyer, but they keep asking you stuff, but you never have the right answer in court. When I say you, this is what I've seen people experience in court. When you don't have the answer, they asked you. You said you were sovereign, but you didn't have no answers. You couldn't solve no problems. So you proved, in fact, that you are a minor and not, and you're not mature to handle these matters because you didn't have any answers. You didn't have any solutions, solve it. You were supposed to brought the answer to the court, not ask the court for an answer. A sovereign bring the answer to the court. They don't ask the court for nothing. They're telling you this is what's going on. It's contradictory to the law, and this is what the law says should be done about this. And it's my recommendation that this be. You can recommend something totally haven't even been wrote down before because the law is created by man, not the other way around. Man creates the law. That's what makes it common. When we keep doing the same thing and having the same results over and over again, that's what's considered as case law. That law was created by the people, actual cases, supposedly. Okay? From real people, real cases. And they were historical in fact, and they were historical in nature in such a way that the person, whoever that case is was about, that made the claim or won the case, made an impression upon the court to the extent that people began to base studies in how to handle cases around that case. That's what case law is. That's what case law, the cases that you create, become law. This is why it's important to create a sound case with proper standing, place it in the proper venue. If you accidentally place it in the proper venue, do not give up. Find out what the proper where the proper venue is. Take that same case, place it in the proper venue. If you are denied at the appellate, it doesn't mean you don't have a case. It might mean you need to go higher. A lot of times that's an indication you need to go a little bit higher because you're asking the court to speak against itself. And that's what this last little indication is. It's letting you know you're asking us to speak against ourselves. And that's not what we purpose to do. It's a conflict of interest to speak against yourself. That's why it's even laws that say you're not supposed to incriminate. There's no laws or practice of laws that's supposed to force you to incriminate yourself. Thank you. We got 2 more subscribers. We appreciate you. And we will show you that we appreciate you by providing good content that you can rely upon that can be checked and verified in any case. It can be checked and verified. You can bring your documents and we can go through those documents and you can submit those documents into the system. It's not a crime, or it's not going to hurt you or harm you to present a case, to get the experience of going into the court and um, dealing on court terms, learning how to get in there, Get in the court, get on out on the field. And it's time to stop hiding behind this player and that player and be front and center, you know. And it's not a team player type of game. It's a every man for himself type of game. And you got to understand that. When you play chess, it's not, I mean, may have, altered it where two people can work on one side or something like that. But the original object of the game is each individual person to think and make their move with their own mind, their own strategy, their own decisions. And many times when you're playing chess, uh, the if somebody come up and start trying to help you, tell you what to play, the other player will get angry because that's not how the game operates. It operates by the let me play this one person head up, every man for himself. Meaning you're not supposed to get no outside help. And if you get an outside help, then that makes the odds uneven. Okay? You got two people, two minds on your side to my one mind. And that is the case in court. Okay? When the lawyer, say for example, you are a pro se and it's just you, but it's you against your opponent and his or her lawyer. Well, that's two against one, isn't it? Well, this is how you reduce it down to one against one. This is the strategy. You must object to the lawyer speaking on the record. The reason you object to the lawyer speaking on the record is because the lawyer only has secondhand knowledge and cannot offer firsthand knowledge of the facts of the case. His word is inadmissible for that reason. When you object, you have to give a sound, valid reason for the objection, and that is the reason. That you can't just say, oh, the lawyer can't speak on the record. That's not a valid reason by according to the rules of admissibility. All right? The lawyers were speaking on the record is inadmissible because it is secondhand knowledge and therefore it is inadmissible. Okay? It is inadmissible because it's secondhand information. And secondhand information is not allowed. Also, is inadmissible because uh, based on your knowledge of the facts, the lawyer was not there. He was not present at the time that the offense occurred or the alleged offense occurred. If you're being accused of something, all right, then it's an alleged offense. And in that case, when the lawyer begins to speak, he can then only ask questions. He can only ask questions. It reduces him down to a position of a pawn on the board of chess. Okay, because he can now only ask questions, and also from that perspective, many times uh, the lawyer, if you have stated your claim sufficient enough uh, to cite any type of activity in dishonor, then the lawyer the lawyer not gonna be quick to do no more talking after that. Shut his ass all the way down because now he's facing sanctionable actions. Um, if he proceed on to try to carry on under the color of law after you've already declared your knowledge of the facts that the color of law is being acted upon under the presumption that you were a minor, and that under the presumption that you don't know what's going on, that all of these procedures that are not in accordance with law, once you make yourself um, clear that you are aware that these things are unlawful, if they continue to act the same way under the color of law, then that makes them liable, personally liable. And so that is the reason why it's sanctionable. That means they have violated the code of conduct that they gave an oath and or made an oath to uphold a certain code of conduct. In other words, if 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 a person lets you know that they are aware and they give you proper notice, hey, I know that you acting under a color law. You need to cut this out. That's like a cease and desist notice, right? So if you do not cut it out and you keep acting like you have authority that you do not have, that's you hear them sirens going off. That's what the notice is for. It's a trying to let you know you fucking up. You fucking up. Hold on. Wait a minute now. You violate my rights. Or you done breached your jurisdiction. You operating um, under the color of law, which means that you are committing a civil offense, which precludes that I have some genuine issues and material facts that I can present to the court to have you sanctioned for misconduct. Hey, 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 wait a minute now. You're doing something wrong. And one thing I like the way Yusuf put it, he say, well, I would like to, he'll say objection. And then he'll say um, whatever his objection is, his objection is. And then and then if the judge proceed, he said that then he would say, well, I would like to preserve the error for appellate court. Because when they make an error, that is the reason for appeal. And you must preserve it in the lower courts before it can even be received in the higher courts. And when I was in the lower court, I did not experience trial to preserve the error. But when I uh, advanced to the appellate level, the appellate judge acted outside of his jurisdiction. And for that reason, I have a right to do a writ of certiorari, which means that he didn't have jurisdiction proper. He went outside of his jurisdiction, and so he wasn't certified to rule on that matter. and that removes his ruling for me to start over in a court of competent jurisdiction, what they call a court of competent jurisdiction. That means that's the correct jurisdiction that should have handled the matter because they understand how it should have been ruled in the first place. And it's got to be error in the first place to be corrected in the second place. Okay? And that's basically what a writ of certiorari is for. I may not be pronouncing it right, but you get my drift. So that's your standing in law. That's how you stand in law. You stand on the facts. The facts of the case is what determine who has jurisdiction. It also determines which arm of the law. You've heard that saying before, that uh, term, the arm of the law, the long arm of the law. Okay? So the short arm is the maximum of law. That's the quick, short rules we go by. That all the long arm is based upon. Okay? The short sleeve garment. That the long sleeve is designed to be an extension of covering of the law. Okay, that's the long arm. Those are our statutes and policies and procedures that we think is laws. They're not laws. We just refer to them in common everyday language as law, but they are not laws. And that's what we want to learn and teach and grow in understanding concerning the differences and what how they are the same. We're not just trying to tell you the difference because there is no big difference in the two. The only big difference between the two is that you need to understand that one that seems bigger than the other is actually not superior. And that's the common things that we consider, the statutes and codes that we consider as law is not law. It means it's not superior to the real law, which is more common. Natural law is more common to all peoples of the world, not of just America, but of the world. And that's the reason why it's called or referred to as common law. Other people can't agree with it. For example, if you get a case and you use a case in as a reference within your case, depending on what level or degree of review by the courts systems that your case receives, um, when it's all said and done, people could be using what you wrote in your claim as case law, okay? Or a guide or governing factor when deciding other cases. That's what citing case law, what its intent and its purposes was originally for. It wasn't meant for uh, lawyers to use as a cop out to actually presenting their own case. And this is the reason why many lawyers are incompetent in uh, effectuating case law, because they just um, go do what other lawyers do, what is common practice, and then for that reason, they never stand out because they just being common. They are common. They are common law practitioners. They're not extraordinary writ writers because they're common law practitioners. And people who think that common law is the superior law are mistaken, because superior to common law is natural law. Common law is just more common. People are more aware of common law because they're not understanding that common law is, but many of them don't understand that common law is based upon natural law. Things you can naturally uh, have an understanding is right or wrong. That's what natural law is. And it consists of. It's like if I do something to hurt you, anybody can understand if I uh, seek revenge or some type of compensation for the damages you caused me. That's natural. That's natural. Easily understandable. You don't need no degree for that. Even a kid know if you hit me, I'm gonna hit you back. And that's how I get my lick back. You know they call it. I'm gonna get my lick back. And so they understand that an exchange need to go on here. You cause me pain, and I need to cause you pain. You know, or the reap what you sow rule. Okay, and a lot of people don't understand. You might say, "Oh, that's just a saying." It absolutely is not. That's a law. What you think is the law is just a saying. What I'm saying is the law. That's how you got it twisted. You know how people say, "Oh, you got it twisted." Baby, you got that twisted. Let me tell you, because you don't know. Okay? I'm not trying to be smart, Alec. I'm trying to help you to be smarter at it. What you know. Okay? What you think you know. For it can transform into what you think you know when you know. Okay? Gnosis, it's spelled G, in Greek it's spelled G N, because the G is silent. G N, yeah, G's moving silence. Gnosis is gnosis. Gnosis. Okay, however you want to pronounce that. All right. And what that means is intimate knowledge. Intimate knowledge. Intimate knowledge. That means your understanding of the circumstances go deeper than what the eye can see or what the ear has heard. And so you can give in-depth uh, understanding of what occurred. And that's what firsthand knowledge is. I mean, you can give more details than another person that wasn't there. They don't have firsthand knowledge of the facts. Okay? So that's what gives you standing. That's what gives you jurisdiction, superior jurisdiction. When you say somebody doesn't have jurisdiction over you, this is what that means. It doesn't mean that they don't have jurisdiction at all. What it means is that your jurisdiction is superior to theirs. It's superior in nature because you have firsthand knowledge. So, since you are the one that has firsthand knowledge, then no one else can present any facts that it that should be held in regard or considered by the court as superior to what you have to say on the record. Okay? And when I say on the record, does not mean you have to talk on the record. Okay? You can write a letter and have that presented on the record. Okay? That's what a performance is. You mail a letter to the court record, the proper court where the issue is being uh, handled. And then that is your presentation of you if you presented it properly as a counterclaim. It should be presented as a counterclaim. I've seen a lot of people give instructions for people to um, start a claim against someone who um, is a creditor. Okay? That is improper. I'm going to tell you why it is improper. It is improper because the person, most, if they have not gotten remedy, it's because they have not presented their paperwork properly. So they need to start at square one. Don't tell them they need to pursue to go to court because they're not even ready for court. Their cases will automatically be thrown out, like the man said, because they're not ready. If they didn't know how to present themselves to the person that they're planning to sue, to the point to urge to create some type of urgency for them to be compliant, they certainly don't have enough ability to present their case to the court and win. That makes sense. I'll give you a good example of what I'm talking about and what I mean. I was renting a warehouse and I had my appliances there. And my business grew so rapidly, I was getting inventory of appliances that exceeded this large warehouse in capacity. To the point, I also had people just dropping stuff off at my place um, because I had it listed as a drop off location for recycling. And so, day and night, night and day, I was getting more units and inventory and things in. Okay, so the managers of the property, he saw that and he got jealous and he envied that. And he started coming over and asking me questions. How are you getting this? What are you doing? And trying to watch me and see how I repair this stuff. I'm try to come and try to make conversation. And I noticed that he was doing that. And I told him, you seem like you asking questions about my business that you don't got no business asking. And that I don't have to tell you how I operate my business, only that I have a business and that it is legal. And that's it. That's the only thing I'm required by law to disclose to you. The rest of it is proprietary. So now imagine he went online and looked me up where he could find out the information publicly. Anyway, he came over there and made arguments with me and told me that he was going to write me up for having too much property, too much of my appliances on the outside of the building. Now, if I was to take you to that property right now today, he has a tenant in that same exact location that's perpetrating as my company that that was his intention to do. I knew it. I knew it. I wouldn't have accused him of that if I didn't know that and feel and I sensed that that's the question. The line of questioning was sneaky and deviant, but not subtle enough where it didn't alert me as to what his intentions were. Okay, and so um, in that regard, I pursued my case against him. When he tried to call himself evicting me, try to get me out to move to do that, I held the fort down. I stayed inside the building. I found out that he can't lock me out if someone is inside of the building. So I paid an armed guard to be there 24 hours a day with me. If I left someone there to guard the building and hold the fort down. What I called it, hold the fort down for me while I go take care of business. And the owners saw how smart and efficient I was in the law and how I trespassed the manager, called the police and trespassed him because he kept on coming over there causing problems. I caught him on videotape, be harassing and being aggressive, and I trespassed him from my property, my area that I was renting. It's my property. So um, when that happened, it made the people above him come down because he could no longer interact without violating the trespass. And also, when I talked to them, I didn't even write any letters yet. This is how powerful when you know your rights and can stand on the correct perimeters of jurisdiction and stand on what they call standing on your square. You're on the right square on the chessboard, all right? When you're a queen, you can make diagonal moves, right? But even in that, you will start or stop on a square, and that's um, your jurisdiction. How the queen can move, that's her jurisdiction. Whatever way she can move on the board, that is her jurisdiction. And what happens if you try to make a move that's out of your jurisdiction? Other players can call you on that and say, "No, you can't move right there. The queen can't do all that. Make a L-shaped movement. Only the knight can make a L-shaped movement." Okay, she out of bounds. Put that back. You got to make a different kind of move and call you on that, right? Well, that's what in stocks is called calls and puts. Calls and puts. I mean, if if they call you on that and say, "No, you can't do that," you got to put that motherfucker back. and you got to start over again. You got to make a move that's within your jurisdiction. Make a move that you allowed to make within your proper jurisdiction. Okay? It doesn't mean that you can't make a move no more. Like when people lose their case, they act like, oh man, it's over. When you saw you should have seen you was about to lose the case. You should have went into action to seek discovery of additional uh, any type of documentation that can substantiate the grounds with which you're standing on. There's always ways to substantiate your grounds. This is why I try to tell people about the Bible. You can take that shit all the way down to the nitty gritty of it and certain scriptures in the Bible that you can use appropriately and it can be effective in law, in the operation of administrative law. Because that's all it is administrative law. Paperwork. The rules regarding paperwork. The rules regarding um, an agreement, even if it's oral, okay? That's the basis of law. Even if you assume somebody was going to do something, you thought they was, all right? That's an assumption of a contract. That's a contract too. If you allow somebody to assume something and you didn't correct it, then they say it's safe for them to assume that. Excuse me. And when I was dealing with those people, they assumed that they could railroad me out of there and it'd be a easy peasy, still her destiny easy type of situation, but it was not. And when I left out of there and I did what I call staging, I made them think that I had valuable stuff in there because it's stuff that looked valuable to them, but it had no value to me. I call that staging. While I actually took the value was already gone out of the building. So if they did seize the property, they wouldn't have seized nothing but trash. It was a staging. It was a decoy. I had already got my valuable stainless steel and top of the line appliances. When he started cutting up, before he started cutting up, I had already planned to move my stuff out into a storage to keep it safe somewhere else. And I did just that. I had 12 storages all over the city. And he paid for it. The owner of that property is he. Because I made sure I did my dealings while I let them know if we do settle this out of court, I want to get this in recorded. I got it on videotape, and I told him, I said, this contract you trying to get me to sign agreeing to taking your money said that you can still come back after me. But I said that we can sign a contract where we don't come after each other. But you trying to be sneaky. I'm the one with the upper hand. So it's best you gone on agree to neither one of us coming after each other. Because if you come for me, I have a right to countersue. And I knew and understood that. People can threaten to sue you all day. But what they need to understand is the other person have a right to countersue you. And if they're better at presenting their case, you can be the one that initiated and be the one that actually do not prevail. And I presented to them, I said, I got video evidence. I've already trespassed your manager for acting out of his purview of responsibility to this property as a manager. And see, and now y'all coming here, and I got y'all on camera trying to call yourself rough me up. But let me tell you, I ain't afraid of you. And the man asked me, he went from his so-called authoritative voice down to his can I please get your cooperation in this matter voice. Okay? Lower your tone when you're talking to a G. So I told him um, I will listen to him to an extent that it be understood I'm not for no bullshit. And I use them exact words or something to the effect. And I did think I used a little profanity. But I let him know. And he was like trying to come back at me. And I basically was like, what part of that didn't you understand? And then he checked himself. Look, we just want to know, why are you refusing to leave the property? I said, I'm not refusing to leave the property. Y'all refusing to refund me my money y'all owe me for luring me into this property. And then y'all think y'all gonna shift me out after I done spent my money into this property and got this property in better condition, and it's worth more because of all the work that I done up in here. And now y'all can see a vision of success in this building that has never been before. And now y'all trying to put me out. Well, I don't mind going somewhere else because I could be successful anywhere. And I prove that from storages all over the city, I did better than in that one location. When I left from there with the money, they didn't give me nothing. That's what I negotiated. And I told them, know that I have a larger case. Because the more I was searching into it, the more I understood what jurisdictions and what remedies was provided to me in a case where I would be a complainant of that nature, and all of the things that they had, all of the counts that I had against them. And I presented myself in that manner to let them know I have evidence, undeniable evidence. And so what we not going to do is play games. And so what we going to do is we going to listen to me. I'm not going to listen to you because your talking have got you here in this predicament that you are in with your balls in a wrench. And so when you thought you had my balls in the wrench, now you know it ain't no fun when the rabbit got the gun. They sent people to torment me while I was there and everything. But when it came down to it, I gave the instructions on how this gonna go down. Now I say I'm cold enough because I had already got most of my stuff out anyway by then. And like I said, I only had stuff there that was a staging anyway. Okay. It made them think that I was trying to stay, but I was already gone. It's setting you up for the checkmate You thought you was finna get a checkmate, and now you captured by trying to come in for the kill for me, and didn't even know I was laying down playing dead. I was laying down playing helpless, so I could lure you in to go for the kill. And a lot of times when people in chess, they always send their big man in. One of their big men, I done call queens like that, snatch your queen up off the board. I done call, I don't usually catch people castle. They don't usually come in with their castle. They come in with the rook. They come in with the knight. But I guarantee you, you come in with that knight, I'm snatching that motherfucker. I got something for him. I got a knight for him. Because that's how my board gonna be set up. It's gonna be set up where that if you come in with that knight, my knight is my knight's is positioned to get you and be safe on top of that from any harm. And so that is what I did. My knights was my expensive appliances that they could in my tools, expensive DeWalt craftsman tools, stainless this and stainless that, top of the line this and top of the line that I had in there that they could have trapped by locking the door. It's called a lockout. Now, they can't do a lockout by law at your residence, but according to the property code in commerce, you got to understand this was a commercial warehouse that I was leasing. So in commerce, they have some type of lien laws and allowances that allows that person is in commerce as well. And so they're allowed to retrieve their value by taking or seizing yours. But they have to do it peaceably. So they cannot come in while you are there. They have to wait until you leave and then sneakily lock you out. Okay? And I say sneakily because there can't be any aggression or fighting or adverse possession. Okay? There can't be an adverse possession, clear and hostile. It cannot be in that manner. It needs to be peaceable. That's what the law specifically says. And I let that man know that. I said anything else is an illegal eviction. And you are trying to effectuate an illegal eviction by trying to strong arm me. And I don't appreciate that at all. I'm not trying to get over on you. It's like, seems like you're trying to get over. Man, how I'm trying to get over when I fix this place up nicer than when I came. And y'all the one lured me in that place that couldn't, in the place across the street, across the parking lot when I initially came, that couldn't even uh, get lights because it was red tagged by the city. And they lured me and got my rent deposit already well knowing that. And I told him I have that against you in court. I have so many different things against you in court. I'm gonna tell you how you come for me. You don't. You absolutely don't. What you do is write out my check for settlement. Well, how much do you want, Miss Johnson? And I told them the amount. And yes, I settled for a low amount because I was not trying to get anybody. I wanted to only be compensated for my loss because I had made money while I was there. You can't make me lose money. I just converted my business, and this was before the corona, so or like at the beginning of the corona, really just shutting everything down. So uh, I had already converted my business into a warehousing type of style business where you had to call. It's called will call. When I used to drive 18 wheelers, we used to go pick up, do pickups, what they call will call. And so I was the first appliance business to convert into that type of company before it became a common practice during the corona. You have to call and you can order appliances directly from my company. We're going to send you pictures of the exact item that you saw in the ad. Uh, it's actual pictures and not models. And so whatever you're purchasing in is depicted in that picture. And people was jumping on it because you also get a 3 to 5 year guarantee. And so, with all that value packed into the sale of a product, my stuff was selling like hotcakes. And what he mistook for the fact that I had a lot of stuff there is that the stuff was just sitting out there like it is at the shop they got. It's just sitting out there. They have a lot of stuff, but they only have a lot of stuff because it's just sitting out there. Nobody's buying that shit. I had a lot of stuff in and a lot out. I had so much work to be done that I was quickly at the stages where I was gonna have to hire somebody to help me repair and prepare the appliances. And so I was hiring people, and he would come over there harassing my employees. Oh, he was doing the most. That's how I got him trespassed, because I caught him in on camera every time he did it, because I had missed it a whole bunch of times. And then when I was reading up on how to build my cases, telling you need documentation. So I wasn't trying to be aggy. I was just trying to make sure I get my proper documentation of his behavior that was inappropriate. And I did that. I plenty of documentation on his ass because he kept on violating. That was dumb. You know somebody document when you doing something. Why would you keep doing stuff so they can document more than one incident of violation? And that's what they had against them. The reason why they settled out of court. So said all of that to say this. If your case ain't strong enough to make a motherfucker want to settle out of court, then you ain't got shit. Then you ain't got no case. If they want to take you to court, despite all your empty threats, because that's what they see it as, empty threats, because they see that you haven't even have the proper presentation for the court to validate your claim. And since you don't have yourself, uh, your presentation in a format that is relatable in understanding to them, that you got a open and shut case, basically. If you have a open and shut case, meaning you had that silver bullet. And for me, I had several silver bullets with hollow point tips on them bitches. That's how I'm coming in a case room, in a courtroom. That's how I shut the lawyer down. I'm coming with that silver bullet with a hollow point tip in that bitch. You understand? I'm gonna shut your ass all the way down. Holler that bitch out. You understand? Holler would be thy name. Thy kingdom come on that ass. You understand? Thy kingdom come on that ass. You understand? Because no weapon formed against me shall prosper. See how I'm wrapping off them scriptures? That's what the Bibles, when I say, when you see in the title and I say Bibles and bills, I was talking about the same thing. I just switched languages. I was speaking the language of God. Script, it is written, no weapon formed against me shall prosper. I am that I am, and besides me there is no other. That's the same as saying, who can testify for me other than me? I have firsthand knowledge of what occurred with me. Whose word in this matter is superior to mine's? That's what sovereignty is. No one can testify on your behalf better than you. That's what that means. That's what that adds up to. That's what that calculates to in court. My word is bond. And that don't mean, oh, I had a freedom to lie if I want to. Nah, that's where you got it twisted. Because you don't have the freedom to lie. That's where the law kick in. That's where the law kick in against you, okay? Because um, it's, the Bible says, should we continue in sin that grace may abound? And then it said, God forbid, okay? And that's what that means. No, you cannot continue on in the presence of the Almighty with an untruth. At least be honest. At least be honest. For example, uh, you'll hear many times I will say, I will admit my faults. The Bible says, admit your faults one to another. Okay? And many times you will hear me say, I'm wrong in ways. I lie, I do this, I do that. Okay? And I'll tell you why I told an untruth or what makes it an untruth. What aspect of what I said was an untruth, or uh, uh, even if I voiced a belief and then I learned better and matured in knowledge, increased in understanding. And so I didn't change my story because this is not a story, it's a learning process. And so what I'm speaking today is different, much different than when I first started. And just because you see a video of me speaking, you don't know how old that video is. First of all, because YouTube, you can, you know, remix and re-edit and all of that, and then um, upload the video, that version, the edited version, at a later date. So that's not really the origin of when that content was created. That's the origin of when that particular version of it was uploaded. That's not the origin of the creation of the content. This is how you can see people who have older videos and the thumbnail don't match the content. Because what they did was they went and got an older video and started copying off of what I was doing and putting these catchy, more catchy, your type of thumbnails. A lot of people wasn't aware that they could even put a picture on their videos. And when YouTube was capturing me looking ugly and crazy, I clicked on that edit section and saw that I could change that. And that's why I started putting my own designs, like a introduction to the content type of Mimi on in the thumbnail area. And then other people started doing it, and I noticed and stuff like that. And I also noticed that there are people now that's starting to create videos that said that they was the first one to do something. And I ain't gonna say no names because I ain't trying to call nobody out, okay? I ain't gonna say no names. But I saw a video where this person made a claim that they was the first to do something. Now, what they claim that they was the first to do, I'm not for sure that they were the first to do that. I'm also can't verify that they were. Okay. Now, I want you to know this. As I pre-stated, you cannot go on the record with a lie and assume that a lie stands as truth because that's not how the record works. You have to go on the record with the truth, and then it can withstand any rebuttal or contest. That's how it remains truth. Because at any time it can be contested. And I am contesting that you are the first to have done that. And I don't even know for sure if there are people who have done it before you, but I'm almost certain that based upon the copycat nature of your content, I'm calling your bluff on that. I feel I have a right and I have ground to call you to the carpet on that. We need to see some evidence, and we also need to make sure this is publicized before other people in this content world to see if somebody else got a rebuttal to that claim. You can't just make a claim in oblivion of your space and then think it stands for everybody. You just said that. I could say, I'm an astronaut. I was the first astronaut to ever land on the moon. And if nobody don't know for sure that if I did that or not, then it stands as truth and fact. No, that's not how this works. Okay? That is not how this works. I'm going to let you know right now. That's why the universe allowed me to listen to your content even after I had already unsubscribed to your channel. I sense bullshittery and copycattery, a lot of copycattery. It's just like you just take somebody else's content and you have a larger following than they do, and you steal their customer base by um, creating content, and you do well with your explanation and so forth of the content and how you go into depth with the documentation and stuff that you're presenting on your channel. I give credit where credit is due. Okay, I wouldn't have been drawn to it if it wasn't presenting that matter. But at the same time, I seen the greediness, all the commercials that annoyed me and made me unsubscribe. All the fucking greedy ass commercials. And then that was a red flag right there. Anybody who have a lot of have commercials on their channels, a red flag goes up, full alert. Okay. And also, I don't want to be bothered with your content, because what I mean by a red flag goes up is something me in me telling me that you don't really hold nothing of value. That's why you think that your content, you devalue your content with graffiti and all them ads all over your content, constantly coming up, while your consumers, your fans, your constituents are there waiting to receive content from you. They are forced to consume content from other people. Now, are you really getting paid that much money to force your consumers to be turned off by your content, to be repulsed by your content? If so, get in where you fit in, like you've been doing. Okay, that's your thing. But what I want people to understand that are new and that are getting into creating content, real valuable content, if your content is valuable in fact, then guess what? That is your value. Why would you degrade it? It's like putting a whole bunch of, you know how people put all them vote for this and vote for that during the election signs in people's yards? That shit is tacky. That shit is tacky as hell. It's annoying. And if I was living in a community and my neighbor had all the motherfucking signs, I'll call the goddamn city ordinance on they bitch ass and had them write their ass up for not having no motherfucking sign permit to have all that debris. That's motherfucking debris. I see it as debris. Because if you can't get out here like the old school and do some door knocking and send your paper representative on that little thing you sticking in the ground in people yard, fucking their yard landscaping up. Because all them little holes create um pockets and mess your aeration off in your yard. And I may be using some terms that people don't understand. They probably like, what this woman talking about, aeration? What the hell is aeration? Okay. People who deal with plants and agriculture know exactly what I'm talking about. Okay? The drainage, the way your water when it rains, the way the water would drain off your grass or through your grass is what's called aeration, I think. I'm using the correct word. But the whole point is that it creates a problem, and that's why I call it debris. And it's just, I don't know how effective it is. I do know that they can use that and call that as an expense for marketing. But how effective it is, I don't know. I don't think they know either. They just all crash dummies doing monkey see, monkey do. That's all I see when I see a whole bunch of signs all in one place. You mean to tell me the only people that vote is right here that's going to pass this corner? What is going on here? Why do you have this many signs in this yard? And how many times do you have to say what you're going to say for it to mean something? For your word is bond. Yay. I'm sounding the alarm from the people, petition from the people to think about your own actions. Think about your own actions while you critiquing the courts, you critiquing the procedure, you critiquing the system. Have you thought about critiquing yourself? You have to critique yourself. There's no honor in critiquing everybody but yourself. That's a narcissistic mentality. To think everybody is out of line and everybody is out of stroke but you. And your way is the right way. Because your way can't possibly be the right way. My way can't possibly be the right way. Yes, I said that. My way can't possibly be the right way. I don't do what I do because I want my way. I do what I do and promote the truth because I want, I am in agreement and in alignment and in acceptance of God's way or nature's way, however you want to put that. It's the same, all the same to me. It's one law, all law. And it's governed by order. That's why when you see law, you see the word order because you don't separate the two. Just like you don't separate goodness from mercy. Goodness and mercy go together. They made it for life. All right. Um, and one thing about it is if you understand relationships, then you can use those words in those terms and understand what somebody's talking about when they are seeming to be talking about family, but they really talking about business because it's all in one the same. Our community business is our family business. The community of America, we as a family of people in this area of the globe, we have a responsibility to other people that are commissioned to care for the global economy. And that's what commissioners is for. They're ministers. They're ministers of the public. They're designed to be there to make sure that if someone is acting in a manner that is in dishonor, that there are um, rules in place and a standard of procedure to go by to say anyone to say, okay, this is how you handle this type of situation. All right, and The reason why it's important for us to speak up when people are acting out of their authority, rightful authority, is because it does not help us when people lose faith in authority figures. So degrading the police as an authority figure is never ever my goal, because I believe in authority. Any sovereign cannot be, experience sovereignty without an understanding that the law is superior and sovereign to every and anything, any existence of anything is the law manifest. Nature is the law manifest. So anything outside of that would be foreign or inadmissible. It's the same thing they say in court, and it's inadmissible. Okay? So that's why I tell a lot of people, when you looking up these documents and you're looking up these videos, and you're so engrossed in learning how to create documents, which is not a superior script. It is not a superior script. What you say, the Bible don't say, um, what's the scripture I have in mind? The power of life and death is in the document you wrote. The Bible don't say the power of life and death is in your affidavit. Or do it. Huh? Or do it. Say something similar to that. Let's slow that word down like we do a application. All right? Apply. Let's run that shit back. All right? And do it and dissect it the same way. What is an affidavit? It's an affirmation that you are the seed of David, and by right have an inheritance to the kingdom of God. Let's recalculate that. Affi, affiant. What's an affiant? What is an affiant? That is the person who is affirming their origin or nature of relation to the beginning. Follow along. I'm taking it slow already. Just follow along. An affiant is a person who is affirming their position as a seed of Jesse, son of David, which is the descendants of Emmanuel, God in us. And some of you refer to Emmanuel as Yeshua or Jesus. That's his nickname. Okay? That's what he's more commonly known as, Jesus. Okay? So when I speak of Jesus, I speak of him in a different manner than you do. I speak of him as that's his nickname, with an understanding that's his nickname. Okay? But he himself is not a person. It's a figure of honor. A figure of honor, deserving of respect. It's a figure, a public figure, depicted in a book for people to gauge their moral standards by. That's why they start these trends and movements. What would Jesus do? So forth, like that. Because in a world where people are losing their moral gauge, you need an anchor. And that's why they say Jesus is an anchor. You know, old folks used to say, you need an anchor. You know, and my anchor's in a rock. You know, the rock of ages. The one who has withstood his stories, has withstood the test of time. That the most retold story is the story of the man. The most versions of stories that have ever been told are the stories that have been told about this man. But I would have you to know that in the Queen Candy version, um, we don't hold the same level of regard for that particular imagery of, of a man. Not because this is the Queen Candy version, but because, as I have afore stated, that many people carry on things as if that is the primary source of knowledge when it is not. And so, in that regard, I openly contest many of the things in the way that the words and the terminology that's is written or translated into, uh, and I don't deem the King James version as valid. However, I do see it as a foundational documentation to reference when giving one an understanding of what a Biblia is. A bylaw is a bylaw. It's just like the articles when you create a corporation. It's your bylaws, the spiritual bylaws. That's why each religion have a different book that's like their Bible. Okay? We're going to talk about Bibles and bills. We're going to wrap it right back around to Bibles and bills because it's all the same. When legislatures um, create bills, they look like script in a Bible. And that's the reason for that formatting, because that's exactly what they are creating or trying to effectuate. It's something that will be scripted, that will remain written, will remain effectual, fervent, active. Like if they don't ratify a law or whatever or statute, then it doesn't have the same effect in court as something that has been ratified. Okay, that's why they'll bring up that term. Now, what I understand ratifying mean is that if in the event that precedence determines precedence determines that we can go ahead and mark this as a, a general or common occurrence, and that's how they shepherdize and so forth and say, okay, this um, started not started a new case, but this marked this, you know, case stood out enough that it created a landmark, so to speak, that we should create laws or some type of governance to, based upon this, because the way the person presented that aspect of the law, um, it stands to be a good um, grounds to rely upon. I hope I'm wording that correctly, but I do understand the full concept. But what I am trying to do is make sure that I do what I urge all content creators to do. Relay the information in a manner that your viewers can properly consume it and understand it and not try to speak over their head. Now, a lot of terms I use, you may not understand. That means you're not a viewer. You should unsubscribe, possibly, because you are a minor. And until you grow up, so you can understand what I'm talking about, if I'm speaking already in simplest terms and you still can't understand, you are obviously not right. Like we discussed in the previous broadcast, is that the man was referring to a case being unripe. Okay? And in your case, you are unripe to receive this type on this level of information. You don't feed steaks to babies. It's improper to do so. And that's no disrespect to people who are still in a minor status. Because guess what? I am in a minor status as well, in some degree. I don't have full knowledge and understanding of how tax law operates. I'm learning it, and from what I can see, is very similar to my structure of investments. And so I will, once I get a full understanding of what's going on with that, I will relay my theory uh, in my own terms of how I view that in totality. But I will say this is that how I view uh, submitting tax documents, most specifically the 1099 series tax documents. I believe that those documents should not be filled out by people who do not have a degree of understanding about court, first, because I will tell you this and disclose this. That is court. Those documents are affidavits. They are forms of affidavits. And when you submit documents and you haven't notarized, that is a form of affidavit on the record. So, in that regard, if you are not knowledgeable enough to understand, for example, when you uh, submit a 1099A, that document can be used for multiple reasons. And how you fill that form out determines how you are using it. Even like other people was using, no, how did you use it? It matters. And if you don't know that that is important, how you're using it, then you won't understand that along with that document, you're supposed to file a 1099C as well as a 1096, which is a cover sheet, just like court. And we'll end on that note. Thank you